TDS, tax deducted at source, on sale of property refers to the requirement of deducting a certain percentage of tax at the time of sale of property and depositing it with the government on behalf of the seller. This provision is applicable under Section 194A of the Income Tax Act, 1961. According to this provision, any person, being a buyer, who is responsible for paying any sum to a resident seller for the transfer of any immovable property, other than agricultural land, is required to deduct TDS at the rate of 1% of the sale consideration exceeding Rs. 50 lakhs. It is the responsibility of the buyer to deduct TDS and deposit it with the government within the prescribed time frame. The buyer is also required to issue a TDS certificate to the seller within 15 days from the due date of depositing TDS. The seller can claim credit for the TDS deducted while filing their income tax return. In case the TDS deducted is higher than the actual tax liability of the seller, they can claim a refund for the excess amount. It is important to note that failure to comply with the TDS provisions can attract penalty and interest under the Income Tax Act. Therefore, it is advisable for buyers and sellers to ensure compliance with the TDS provisions to avoid any legal and financial consequences.